If there's no will, the law decides, not you.
You're probably thinking, my family would never fight over property. These aren't movie scripts. There are real cases right here in Singapore. Perhaps triggered by poor planning and blind assumptions. Most people think we are family, things will sort out themselves. That assumption can sometimes lead to a mess. Many people assume that if we love and trust our family, we don't need to write a will. But the truth is, when someone passes away, even close family, can sometimes find themselves divided. And if you co-own a home with someone, perhaps your spouse, what you intend and what actually happened after you are gone can be very different. Without proper planning, even strong family bonds can be tested by confusion, delay, or dispute. In Singapore, when you co-own a property, there's something called the manner of holding, and it decides what happens to the property when one owner passes on. There are two types: joint tenancy and tenancy in common. Choosing the wrong one or not knowing which one you have can cause problem later. Joint tenancy means both owners are treated as a single entity. You each own 100% together, not half it. So if one owner passes away, the property automatically goes to the surviving owner. This is also known as the right of survivalship. The flat doesn't form part of the deceased estate. With tenancy in common, each owner owns a defined share of the property. For example, 70-30, 50-50 splits. Both parties are treated as a separate entities. If one passes away, their shares become part of their estate. It doesn't automatically go to the other owner. What happens next depends on whether there's a clear estate plan, like a will. So what happens if someone passes away with no will? Here's how Singapore Intestate Succession Act distributes the estates. If you have a spouse but no children or parents, your spouse inherits everything. If you have a spouse and children, your spouse gets half and the children share the other half equally. If you have children but no spouse, the children inherits everything equally. If you have a spouse and parents but no children, your spouse gets half and your parents share the other half. If you only have parents, they inherit everything equally. If there's no spouse, no children, or no parents, your siblings inherit equally. If no siblings, then your grandparents inherit equally. If no grandparents, it goes to uncles and aunts. If no relatives survive, your estate goes to the government. Now, let's revisit those headlines. 3 sisters sued their brother over a shophouse that their father left them, and they won a 25% share each. 84 years old blind widow took her own children to court to recover 1.37 million. She said it wasn't a gift, and the court ruled in her favor. A grandmother and grandson fought over a Tanjong Pagar flat. Both lost. The judge dismissed both claims. And in another case, siblings fought over 8 million shophouse. The brother won, but not without heavy costs and a damaged family bond. If there's one takeaway, it's this: dispute can arise even with or without planning, when expectations and legal reality don't align. And many people are surprised to learn that having a will doesn't always prevent conflict. A poor written or outdated will can still be challenged, especially if expectations don't match what's written. And from time to time, we hear in the news about families going to court to contest a will. Sometimes it's due to unclear wording. Other times it is about whether the will was signed properly or weakness. The truth is, a will is only as strong as how clearly and carefully it is prepared. And that's why it's not just about having one. It's about making sure it's valid, updated, and aligned with how your assets are held. And if you are not sure whether yours is, it's a good time to get a second opinion, ideally while you are still clear-headed and in control. And here are 4 simple steps you can take today. Step 1. Check what is the manner of holding of your property. Is it joint tenancy or tenancy in common? Step 2. Write or update your will. Step 3. Review your CPF nomination. CPF doesn't follow your will. Step 4. Set up a lasting power of attorney, LPA, in case of mental incapacity. It is not complicated, but it does take intention. You might be thinking about downsizing, retirement, or passing your flat to someone you love. But estate planning isn't about wealth. It is about love and making sure that your loved ones can honor your wishes. I'm Kenneth, and I'll see you in our next video.